Accountants, gain the tools to future-proof your practice against this current climate of great change. The must-attend Accountants Daily Strategy Day, now in November, will provide you with the latest industry updates and tips for modern practice management to combat the changing regulatory and consumer landscape. Learn about the technology, processes, strategies, and trends shaping the future within the industry from top experts and government officials. Limited tickets are available. Visit accountantsdailystrategyday.com.au to secure yours now.
This is a Momentum Media production.
Accountants Daily Insider, a behind-the-scenes look at the biggest news in the Australian accounting profession.
Hi there, it's Jotham Leon from Accountants Daily Insider. We're bringing you a special episode from our sister title, SMSF Advisor. Thanks for listening.
The SMSF Advisor Show, your expert insights into the biggest themes shaping the SMSF advice industry.
Hello and welcome to the SMSF Advisor Show. I'm your host, Jotham Leon, and I'm joined by my co-host, Aaron Dunn, Chief Executive of Smarter SMSF. Aaron, how are you? How's anything new for you?
Oh, no, just another day, wonderful day in lockdown in Melbourne. So, 200 and whatever it is now. So we lost count after that. So after... the only donuts we get in that is the two that go after the two, as in 200.
Well, we're pushing 2,000, so here in New South Wales. Well, we're in the same boat, I reckon. But yeah, let's have a quick catch-up of the SMSF news from over the past 2 weeks. And I think the big one is the ATO releasing its SMSF quarterly statistical report for the June 2021 quarter. Now, it's a great snapshot of the industry as a whole, and now we can see that there are about 1,114,000 SMSFs, up from 1,070,000 last year. And I think this is the first time that we've crossed the $800 billion asset mark. What's anything surprising from that snapshot for you, Aaron?
No, I mean, what we've obviously, that $800 billion figure is a fairly substantial figure for the industry. It would show quite clearly that markets have recalibrated, obviously post-2020 through the GFC COVID, I should say, where we saw the adjustment. Yeah, we saw that previously with the GFC, and then we've kind of seen a very similar upswing again in 2020 and then obviously into 2021. So a lot of the statistics that we see are really continuing on trends that we are seeing in the industry, new entrants and so forth. To me, I really like getting my teeth stuck into the annual statistical summary that the ATO releases. Some of the data you see in the quarterly report is very good, but there is also then a reset of some of that data that is done in the following one, because obviously there is a cutoff point that the ATO needs to do. So I used to be absolutely engrossed in all those. I spend a lot more time in the annual data because of the depth of that information, but rightly so. I think that $800 billion figure is something that's worth celebrating in the SMSF sector.
Yeah, if you're talking about annual statistics there, I think what surprised me was how little wind-ups we've seen over the past 12 months. I mean, there were just 2,200 wind-ups over the last 12 months compared to the usual 15 to 20,000 that I've seen in previous years.
Yeah, so the ATO did do a fairly hard cleanup over the last few years. So funds that, did they actually exist or didn't they exist, and it had been in contact with trustees and really got nowhere. So we will continue to see funds as clients get older, obviously looking at, has an SMSF reached its use by date and that sort of stuff, but we're not going to see that same rate of wind up that we may have in the past. I think that's a pretty fair assessment. And the reason why I say this, we're seeing a much younger entrant coming in. So that time frame or longevity of those funds will obviously last a lot longer than potentially that we've seen those that were established maybe in the last 10 and 15 years. And so where they were established at a much older age, say people in their mid-50s and the like, maybe moving into retirement. So there is this kind of undercurrent of change that is going on because we are seeing much younger entrants. But by the same token, we are seeing establishments up, wind-ups down, but we're not going to see big jumps in either of those either, in my view.
Yeah, you're talking about young entrants, and about 86% of all SMSF members are 45 years and above. But I think individuals aged 35 to 44 make up the majority of establishments, new establishments now. So that's quite interesting. It's getting younger. It's definitely getting younger.
Yeah. And the reality of that is, I mean, I look at myself just over that age group, but we won't go into that. But in essence, we've had compulsory superannuation our entire lives. So whereas if we looked at that previous set of baby boomers and stuff, they built up wealth, but they never had that compulsory level of superannuation. So to get to a $200,000, $250,000 threshold, people in their mid-30s, maybe as a young family, a couple, quite clearly they're going to get to 200 a lot quicker than generations before them have. Yeah. So that is why we're seeing that level of interest. There is a more diverse set of asset classes that people could be looking at. And I say that in SMSF, obviously property and the like, but we're also seeing digital currencies and all that sort of stuff as well. Not to get into the conversation of what's right and what's wrong, but we are seeing a more diverse range of asset classes that are available, which then opens up the opportunity for more and more people to look at the sector and see whether an SMSF is right for them.
And I think this ties into a Class's report that was released last week as well. And it was just saying how SMSFs were thriving despite COVID-19, the pandemic, and all the underlying economic situation at the moment. So I think it's just going to be a pretty good road for SMSFs ahead. You see pretty rosy.
Yeah, I mean, I always go back to, and again, this shows my age, but, Jeremy Cooper in 2010, when he did the Cooper review, the Super System review, found SMSFs were pretty well-functioning sector. And, when you look at reviews since that point in time, the only sort of blip on the radar that we've seen throughout that period was about borrowing in super in the Murray review in 2013. But even with that, the SMSF sector continues to go through as a well-functioning sector. So we've led the way in terms of retirement incomes. A large majority of funds are already paying pensions, and that sort of stuff's been acknowledged through retirement income reviews. So there are elements of this multi-trillion-dollar sector that SMSFs continue to lead the way in, and I think will continue to do so in the future as well.
Okay, moving on to other news. We also saw the passage of Treasury Laws Amendment 2021 Measures Number 6 Bill, which removes the requirement for superannuation trustees to provide an actuarial certificate when calculating its exempt current pension income when all fund members are fully in the retirement phase for the entire income year. The bill also improves the visibility of super assets in family law proceedings by allowing the ATO to release super information to a family law court upon request. Any surprises there, Aaron?
No, both were expected. Importantly, that ECPI one has been around for some time, something I got quite frustrated with when I first read the legislation back in November of 2016, and it came law in 1 July 17. It's taken this long to try and fix that problem. So it is nice it does have a 1 July 2021 effective date, which means the tax return for the 2021-2022 financial year will mean that if in a very simple perspective, if a fund was, say, a sole member fund or a two-member fund and they had 100% tax exemption, but they were over the 1.6 mil, they would no longer need to get an actuarial certificate in that set of circumstances where up until now they needed to. So yes, it is a reduction of red tape in its absolute purest form, which is a good outcome.
Yep. And last but certainly not least, the government has announced that ASIC's levy for financial advisors will go back to 2018-19 levels of $1,142 per advisor for the next 2 years. Now, that's going to be a big relief for advisors who were scheduled to pay $3,138 this year. Aaron, was that a huge surprise for you?
It was a pleasant surprise, I think is the right way to explain it. The reality is the cost of advice is becoming more and more expensive because of the way that the ASIC funding model was going to work. Quite clearly, there'd been some significant pushback from within the industry as to the impact that is having on affordability of advice, and quite clearly, talking to advisors and stuff, really having to strip down the type of client and the minimum prices that they'd be charging clients. So it was becoming more and more difficult. So this is an important step. Obviously, it freezes the fee in respect to that advice, but whether we come up with a better model beyond that 2-year period, obviously the government is still implementing a whole range of measures from the Hayne Royal Commission, and we are seeing the government committed to a quality of advice review, obviously in 2022 as well. So there's a lot of water to go under the bridge over the next 18 months. So hopefully that 2-year transition or 2-year grace period that they're giving around this allows us to see some much clearer waters as we head well into 2022.
Yeah, so they're going to do an industry funding model review in 2022, and we'll definitely be keen to see some submissions from the professional bodies as well.
Yeah, absolutely.
Now, all right, in the build up to this year's SMSF Advisor Technical Strategy Day, we're also going to showcase some of our esteemed speakers. So today we're starting with Clinton Jackson, partner at Cooper Grace Ward. Welcome, Clinton. Thanks for joining us today, and thanks for agreeing to speak at the upcoming Technical Strategy Day. Now, your session is titled Wealth Transfer, Critical Insights into Estate and Succession Planning. Now, we don't want you giving away too much, but maybe could you give us a little bit of a preview into what you'll be covering at your session?
Excellent. Thank you for having me. In our session, we're going to be covering off on obviously all the emerging trends that we're seeing in that super and estates dispute area. Some of the main things, obviously, you would have been reading a lot about over the last few years, in particular trustee discretion and conflicts of interest. They're sort of the two of the main areas that I think the industry still has a fair way to go to making sure we deal with those issues properly.
So conflicts, I think if we maybe drill down a little bit on that, Clinton, because I think that's a really good area to understand, because we have over a long period of time now seen decisions of the court really come about because of a discrepancy and a conflict in the view of the trustee and potential the beneficiaries, and therefore the relevant documentation that was in place being challenged, or the process. So maybe just briefly maybe touch on a couple of cases that you've seen where you've found some conflicts in play and what has obviously transpired from that.
Yeah, so absolutely. In terms of conflicts, obviously, we've started with the industry getting a little bit too comfortable in assuming we can just do whatever we like with trustee discretion. And unfortunately, I guess until the recent court cases that we have started to see some of these issues creep in, that's probably been generally reinforced by some of the decisions around binding nominations and that we had earlier on in sort of the early sort of 10s along the way. But realistically, the whole conflicts does sort of dictate to us that where you are exercising that discretion, you've got to be really mindful of what your duties are as a trustee. And there's that whole area of trust law that exists, which does apply to self-managed superannuation funds in terms of how we make the decision, what considerations we need to go through, and how we actually then give effect to that process. And I think it's been one area where I guess the industry as a whole hasn't really focused on the elements that go into exercising that discretion. And it's something that is really critical to ensuring the death benefit decision will be upheld. And I think what we're going to see, and we have started to see this trend come out in the cases, is that will continue to be an issue when we are reviewing things like binding nominations or decisions about how death benefits are made. Where we often see it, and I think this really does exist in almost every self-managed super fund situation, is you've got that plain vanilla mum and dad super fund. Everyone thinks, okay, well, we're not going to do things like binding nominations or reversionary pensions because we're going to leave it to trustee discretion and give the benefits that flexibility do offer for that sort of tight-knit family situation. But immediately in those situations, you do have that conflict issue arising when you are going to go pay that superannuation death benefit when one of mum and dad die. Now, we probably don't see too many issues arising there because generally the kids are on board and everyone's happy for mum and dad to treat that as their own money. But that is the most basic form of conflict you can ever find. So making sure we deal with those issues and making sure they're addressed properly, even in the basic mum and dad situations, is going to be important to ensuring that when we get a more complicated family situation, particularly like blended families, that we have addressed all those issues properly, because that's where we are starting to see those disputes, stepchildren, new spouse, those types of things, people exercising discretions that benefit themselves are going to be put under the microscope with what we're seeing in the emerging cases.
So, Clinton, if I could ask you just to elaborate from there, we have seen some disconnect between the role that an attorney may play, say under incapacity, and when that role may ultimately cease. And then whilst we don't necessarily see a legal personal representative being different, again, looking at documentation and making sure all the ducks in a row, I guess one example of where this can actually throw up some pretty significant challenges.
Absolutely. And often when we're talking about estate planning and death benefit payments, we are thinking about who's going to control that payment when we have died, who's it going to be paid to. And even if we get that bit right, often what you do see is that attorney piece and that period of incapacity before someone dies not being dealt with properly. And the most basic error that we see is no thought being given to the fact that the controllers could be different during that period of incapacity compared to the period post-death. And obviously where you do have that difference in controllers, depending on how we've structured how that death benefit would be paid, you can end up with some conflict between the decision makers. Is it really the attorney that we wanted to be in that role with discretion as to how that death benefit was going to be paid? If the answer to that question is no, then we haven't done something right in the planning process because we've chosen either the wrong person or we should have gone further and put some extra protections in place to ensure that that conflict between the decision makers didn't occur. So that period of planning for incapacity and planning for death really need to be looked at together to ensure that we sort of have a plan that's cohesive. And often we see that that's sort of an area that is overlooked.
Now, Clinton, you mentioned some growing trends in estate disputes. Will you give us a little bit more insight into that, into what you're seeing that's trending at the moment?
Yes, sure. I think realistically, following on from what we were just talking about, attorney disputes is a really big one that sort of is continuing to gather some attention, particularly decisions that the attorneys are making along the way immediately before death, where they are either obviously destroying or selling a gift that was otherwise intended to go to someone. Or we had one a couple of years ago now where the attorney was the new spouse, and the new spouse drew out significant pension payments more than the person needed, but used that money as a general pool fund to go buy new assets solely in her name. So obviously taking away assets from the estate, which were intended to be split up differently. So attorney disputes is a really big one. And attorneys, unfortunately, don't properly account for the work and the stuff that they do. We see that as a really big risk area moving forward. And I think if you are ever appointed to act as an attorney, it's one of those areas that you should be really, really mindful of. The other one is that all the general estate litigators have cottoned on to the benefits of attacking the super fund. They all know how much money is now in super throughout Australia, and they've now sort of gathered the skill set necessary to be able to at least create enough trouble that it puts the super on the negotiating table as part of the estate. If you go back a few years, they really never really focused on that element, and they sort of just brought their general claims or estate challenges, and obviously were leaving out a fairly sizable chunk of most people's wealth. But now they are sophisticated enough to understand and know the loose threads to pull on to at least make super part of the conversation. And I think that's a really big risk for all of us.
Clinton, you and I have been pretty consistent on this the last couple of years that, you know, there's been a lot of discussion and debate about challenging of binding death benefit nominations and so forth. But pensions, I think, is another area that we're going to see far more heavily contested in the veracity of the documentation that exists as well. So I'd be interested in your thoughts around, you know, you often talked about emerging or growing trends. I see this pension documentation area and the validity of different nominations and stuff being one of those areas. And as I said up front, you and I have been fairly consistent on this. So I'd love for you to share your thoughts on it as well.
Yeah, I think, Aaron, obviously pensions is one of them, but I think we can probably broaden that out to just documentation generally. And I think focusing on pensions first, how many full sets of pension documents with all the supporting resolutions and everything do you ever see? Not very many. I can tell you we ask regularly in all the different advisory work we do, and you can rarely get your hands on the complete set of documents starting the and unfortunately, those summary pages that are often what people give you to evidence their pension, they're just not enough to really justify it to the extent we need to when having things like reversionary beneficiary nominations upheld. So quality of the documentation and the ability to put your hands on it at the right time is going to be critical. And we saw that as an issue in obviously the Narriman case. And I know you and I have had lots of conversations about that since then. And that we were fortunate enough to fluke the outcome and get the court to agree that a pension was reversionary. But that's because it was a lifetime compliant pension and we had all the other actuarial evidence around that. For every other normal account-based pension or even your average market-linked pension, that information isn't going to be available to help us justify a position, I guess, to the extent needed to have a court uphold our position. So having our source document is going to be critical, or at least putting in place enough to justify we've arrived at if we can't find them. And I think the same goes for bindings. Obviously, we need to be able to put our hands on the source documents. That's going to be critical. But trust deeds and trust deed history is a really big issue. It's been very, very poorly managed over a number of years. And there's very little that can be done without great expense to fix a lot of these issues. And we saw that as an issue in Narromine. And obviously, since Narromine, we've embarked on a significant number of trust reviews for clients of ours as part of estate planning files. And most of them don't hold up to the blowtorch. If you look through the deed history and you try to sort of apply a consistent approach as to how they've done their variations and changes of trustee, most of them don't have everything they need to be valid.
Yeah, I can attest to that. I reckon I'm having a conversation like that at least 2 or 3 times in every month. So, yeah, it absolutely is that. And as you said, the cases that we've seen going back now where, before they've even kind of opened the book on it, will show us everything, show us all your files and let us actually work out whether the 8 variations that you've actually done are enforceable or not. Where's the gap to say, well, if deed 3 is the one we've actually got to go back on, well, that's what we're looking at. And it doesn't matter whether you've done DBNs and pensions and stuff that comply with deed variation number 8. It's irrelevant for the context of me making a judgment in this case.
Correct, yeah. And we had one not that long ago where there were 8 variations post the first deed and all 8 of them were invalid. So you went back to the original deed. Yeah. And that was solely because the first one had a major flaw in it. Yeah. So every deed thereafter that never went back to the original and checked made the same mistake. And obviously once you got a chink in the armour, unfortunately, with the way we do wholesale replacements for super fund deeds compared to discretionary trust deeds, that chink in the armour doesn't get fixed. And we saw that as an issue once again in Narromine, as I said. And when we did the 2014 variation there, we went back 3 or 4 different deeds and made sure the variation we did was valid through for all of them, depending on which one actually ended up being valid. And I think when we went in front of there was only one of those 4 that were valid, and we just happened to cover that off in the deed we did, which is what we suspected at the time, but it's always nice to have that confirmed by the court. Yeah. So, but if we just relied on the last version, we would have had a problem.
Now, Clinton, if I can just turn your eye to member SMSFs, I mean, that's a new thing that we have this year. Do you see any issues and opportunities there with 6 member SMSFs?
Absolutely. I think there's pros and cons on both sides. I know some people are excited about them, and for certain families, they will offer the opportunity to potentially keep some assets in the super environment to have more members. In terms of having, obviously, other members with greater balances will allow to keep sort of marquee assets even after mum and dad have passed away. Yeah. Unfortunately, with the way super rules are, though, we still have this death benefit issue, and it's not like 6-member funds magically allow us to deal with death benefits in a more intergenerational way. We are still stuck with the requirement to having to pay a death benefit. So I think the real benefit from succession planning probably isn't as great as what some people are hoping they are, other than obviously it does cater for, I guess, a more diverse family situation in terms of having more members. I think on the flip side, there are potentially more cons in the sense that we have more people sitting around a table having to agree, and whether that be on day-to-day decisions, but particularly death benefit payments and discretion and those types of things. If we don't have proper estate planning, I think there is a greater risk that you're going to run into more disputes as to how that stuff's dealt with, particularly when you're having arguments about validity of binding nominations and reversionary pensions and what should happen.
So, Clinton, with that, do you see potentially a greater focus towards maybe more specialist built deeds, being tailored? Because, there are, as the number of members may grow, and this, I don't necessarily take the view that the more numbers, the greater the issues. I mean, there still could be plenty of issues inside a 2, 3, 4 member fund when you start to layer, generations that are looking at the asset pool. But the fact that there's, in a standard deed per se, there's a uniformity in decision making, but there are going to be key decisions over the time that may require a different standard of acceptance by the trustees as opposed to, just a 50% approval. Do you start to see that may be where we are going as an industry, where in particular with large asset pools, that if a member becomes incapacitated, that all of a sudden we need to think about decision making in the fund maybe having a much higher threshold than what may be afforded when all members actually have their faculties at this point in time.
There's a reason why they say that the perfect number of members in a self-managed fund's one. Because they're the easiest situation to deal with. And then I don't think it really matters what your deed says or how you structure your arrangements. As soon as you get beyond that, some thought needs to be put into what really should the mechanisms look like. Now, the way I sort of explain this to people is if you're going into business with someone, if you've got one other business partner, well, you sort of accept that you have to get on, and there's going to be situations where you're deadlocked, and that's just life. But if you go into business and you've got 10 business partners, you're probably going to put some more thought around what rules are required to bring someone into the business, sell the business, do all these other things about buying big, large pieces of equipment and those types of decisions. So I think we should be applying the same sort of methodology towards self-managed super funds.
So a shareholders agreement, but for SMSFs.
Well, sort of, yeah. But like in terms of tailored documentation. So not just grabbing what's off the shelf, because that's not going to fit every circumstance.
Correct.
You need to have sort of that more thought around how decisions should be made.
Yep.
Some things should be just majority. You don't want everyone having to do everything. But key decisions need to be obviously thought about in terms of what threshold we need. And I still don't think you want unanimous, because you don't want one stick in the mud ruining the party for the other five. Yep. So you've got to be really careful with how those things are crafted. But I think as an advisor, if you're allowing a client to go into a 6-member or a multi-member fund without raising these issues, I think that's a pretty big risk. And from an advice point of view, I'd be hoping all our advisors are at least raising this as an issue. And I think still the best approach there is you got to give the client the option. You should be speaking to someone to get something tailored. However, if you don't want to, here's a standard offering that might suit you. And that's really the only way as an advisor you can probably deal with that issue, I think. So,
All right, Aaron, any more questions for Clinton?
No, my only final one, Clinton, was just what you'd be impressing on advisors in the conversations with clients around the topics that we've spoken about today.
I think that really the issue is making sure that clients pay enough attention to this stuff and invest the time and sometimes obviously the money necessary to do it properly. There's still an aversion obviously out there at the moment. Times are tough for some people. Estate planning and succession planning is not an area that people like to willingly spend lots of money on. But I'm sure you've seen it, Aaron, there is a distinct difference between someone who's spent the time and effort to do it properly versus someone who's tried to put a Band-Aid solution or a quick fix in place. And those are the ones that you're going to see are going to continue to cause issues into the future because they've dealt with part of it and they haven't dealt with the whole problem needs to be dealt with together so that there is a cohesive solution that applies across the board and obviously links the estate, that incapacity piece and their structures, which includes the self-managed super fund into that to ensure that it's done properly.
All right, that's perfect. Thank you so much for your time today, Clinton. We really appreciate it and we look forward to your session at the Technical Strategy Day.
Excellent. Thanks for having me.
Thanks, mate. Cheers.
Cheers, mate.
So, Aaron, that was quite the insight piece from Clinton. We didn't want him giving away too much or asking him too much. Not his session would have been pointless. But what did you make of that chat?
Clinton could talk on this topic for days on end, so there's no problems in terms of what he's covered today. You're going to get a hell of a lot more, obviously, from his session at the SMSF Advisor Strategy Day. But what it really does impress on me is the importance that advisors can play to identify these issues and actually have the conversations with their clients. You don't need to know all the answers, but there's a role to play in identifying what the potential issues are. Blended families are obviously going, in a very simple form, are going to trigger potential issues. The fact that, dealing with incapacity or making sure that documentation is in play and is properly in order. So whether it be a trust deed or whether it be pension documents, death benefit nominations. And in a lot of instances, it may require people to kind of revisit that. Even though your clients think you did it perfectly from day one, the reality is the rules have changed and things move on. and there may be gaps in it. And the gaps in it, if the time, effort and energy and maybe money is not spent now, there is going to be a hell of a lot more that Clinton's going to be able to have in his pocket, paying school fees that lawyers have for all their kids and all that sort of stuff out there. I'm just joking, but yeah, that's the reality. And I mean, he made comment in his session about the fact that litigation lawyers now more than ever are becoming schooled up on this area. So I might say that in jest, but there's a very serious undertone to it as well, that if we're not doing this stuff and doing this stuff properly, it will put the client at risk and then potentially expose the advisor as well.
Yep. So have that conversation now.
Yep.
Now, if you want to hear more from Clinton and our other great lineup of speakers, including Aaron, of course, then please register for our SMSF Advisor Technical Strategy Day. It's going to be live and virtual, so you'll be able to access it from wherever you are. And if you like this episode, you can check out other episodes on Apple Podcasts, Spotify, and other platforms. If you have any feedback, the best email for that is editor@smsfadvisor.com.au. Thanks, and we'll see you next time.
If you like this episode, you can check out other episodes on Apple Podcasts, Spotify, and other platforms. If you have any feedback, the best email for that is editor@accountantsdaily.com.au. Thanks, and we'll see you next time.
Are you looking for a flexible and rewarding career? Have you considered expanding into mortgage broking? The free-to-attend New Broker Academy will set you up with the right tools, tactics, and knowledge to put you on the best path to expand out to new clients, increase your revenue stream, and ultimately capitalize on the current boom within the mortgage market. This 2-day virtual conference is jam-packed with engaging sessions from specialist speakers to fast-track you and your new brokerage to success. Learn why expanding into mortgage broking will be the best decision you've ever made. Visit newbroker.com.au for more information or to register your free spot to attend.